Well, good afternoon, everyone. I'm Martha Minow, and it is with real pleasure and delight that I welcome you to the Vaughan Academic Panel. This is an event that we hold every other year. In between years, we have a lecture. I actually love the panel process because it leads to a great and vibrant discussion. It was created with the inspiration and support of Herbert W. Vaughan, otherwise affectionately known as Wiley, who was the class of 1948 here at Harvard Law School. And he endowed a fund to advance understanding of the founding principles and core doctrines of American constitutionalism. And because he wrote about it so eloquently, I'm going to quote him. He believed that, and I quote, "The Constitution of the United States is the greatest practical achievement of political science." He went on, "It is a testament to the extraordinary gifts of creativity, prudence, and high-mindedness possessed by the founders of our nation. May you be guided and inspired by their genius as you meet the challenges of the present day." And it is, therefore, with tremendous honor that we welcome Professor Lawrence Alexander, the Warren Distinguished Professor of Law at the University of San Diego School of Law. He's going to speak about relationships between law and politics, and really there's nobody I'd rather hear from on this subject. He teaches and writes about constitutional law, criminal law, and jurisprudence. And some of his notable publications include Demystifying Legal Reasoning and a terrific book, Crime and Culpability. The other outstanding panelists who are joining us today are James Stoner, who's the Hermann Moyse Jr. Professor at Louisiana State University, Dr. Matthew Franck, Director of the Simon Center on Religion and Constitution at the Witherspoon Institute, and our very own and beloved Professor Mary Ann Glendon, the Learned Hand Professor of Law. Larry, thank you so much for being here. All of you, thank you. And please, go to it.
Okay, well thank you. Thank you, Martha. It's a pleasure to be here. It's been a while since I've been in Pound Hall. And anyway, as Dean Minow has said, my topic is law and politics. Question, what is their relation? That's the topic about which I've been invited to speak. As a professional matter, I'm afraid that although I know a few things about law, I really know nothing about politics. What I remember from my college courses in political science can be boiled down to the Harold Lasswell view that politics is about who gets what, when, and how. So I come to this topic with a very limited toolkit. Nevertheless, I shall take out my hammer and see if I can turn the topic into some nails. My forte, if I have one, is taxonomy and analysis. Not exciting, perhaps, but I hope clarifying. And clarity is, in this as in so many matters, a necessary precondition for wise policy, and confusion is a recipe for disaster. So first, I'm going to make some stipulations. One, politics, as I shall be using the term, is the process of deciding what a group or a part thereof should do based on first-order practical reasons. First-order practical reasons are all things considered reasons, moral and prudential. Those reasons may dictate that a particular action should be taken or omitted by a particular actor in a particular situation, but they may also dictate that all or many actors should take or omit a particular action in a range of situations. Second, law, as I shall use the term, is those norms that through the first-order practical reasoning of politics, those who have the authority to do so have decided should obligate those to whom the norms are addressed. Although it is perhaps not the only outcome of politics, it is the most significant outcome. The primary aim of politics is to produce the norms that are law. Three, legal norms can be either rules or standards. It's an old story here. When they fully determine what the law's subject should do in a range of situations, they are rules. When addressed by rules, law subjects are supposed to do what the rules require rather than what they believe their first-order practical reason dictates that they do. When those norms do not fully determine what the law's subject should do, but instead leave open a domain in which those in which those subjects should follow the dictates of first-order practical reasoning, then those norms are to that extent standards. 4, why have rules at all? In other words, why not decide everything by means of first-order practical reasoning? Put differently, why is not our only law what I call the Spike Lee law? Do the right thing. The Spike Lee law is the queen of standards. Lesser standards are circumscribed by rules. But what is the problem with the Spike Lee standard? To repeat, why have rules at all? The answer is obvious. When I ask my first-year law students this question in their very first law school class, they have no trouble coming up with the right answer. In a society such as ours, people cannot agree on what the right thing to do is. There are many reasons why they cannot. First, they differ about what the correct moral principles are. Second, even when they agree about moral principles at an abstract level, they disagree about how those principles apply. For they disagree about the factual matters on which correct applications of moral principles depend. And that means that at least some of the people, even if well-motivated, will end up doing the wrong thing. Moreover, because of these disagreements, they cannot coordinate their actions with those of others. And the lack of coordination will produce huge moral costs from everyone's perspectives. Thus, settlement of what ought to be done is necessary to avert the moral costs of mistaken moral views, mistaken applications of correct moral views, and lack of coordination. And settlement is achieved by determinate rules. Even first semester law students understand this when asked, why not just the Spike Lee standard? 5, having now discussed politics, law, legal norms as either rules or standards, and why rules are desirable, let me turn to the topic of legal interpretation. Some, even members of this faculty, believe that there is no one thing that interpretation is. And I agree that there are many things that can be called interpretation. But we should not get hung up on the word. What we need to ask in the legal context is what the proper approach by those subject to laws, what is the proper approach when those subject to laws questions, or when those who are subject to laws, when questions arise regarding the meaning of those laws. That is the activity we should be interested in when the topic of legal interpretation is broached. The important distinction here is between those to whom we have given the authority to determine what norms we should comply with, the legislators, and those who are supposed to comply with the norms legislated by those with legislative authority. The latter group includes all the addressees of the laws, judges and ordinary citizens alike, as well as legislators in their capacity as ordinary citizens. But if judges and citizens are supposed to comply with the norms produced by those with the authority to produce them, then when those norms are promulgated and encoded in a text, judges and citizens are supposed to figure out what the norms are that the legislators encoded in that text. In other words, they are supposed to figure out what the intended meaning of that text is. Not just any meaning that the text might have were it authored by other than its actual authors, or for purposes other than conveying what norms those with the authority to do so have determined should govern. The legislators have decided upon such norms and have attempted to convey to the rest of us, judges and citizens alike, what those norms are in the only way possible, which is through symbols. The symbols are their code, and if we do not seek to determine what they meant by their code, then we will not ascertain what norms they intended for us. And that will be to deprive them of the legislative authority that we purported to give them. Instead, we will have transferred that authority to others or to some mindless process, such as the meanderings of linguistic usage. A text, untethered from the meaning its authors intended to convey by means of it, is just a set of marks or sounds that can mean anything whatsoever. But as the code chosen by its actual authors to communicate the meaning they intend, it means what they intended to mean. Any other meaning attributed it reduces its authors, in our case legislators, to nothing more than producers of marks and sounds. They will not be producers of legal norms, and thus they will not be what they are supposed to be, legislators. So legal interpretation, properly understood, is the attempt to ascertain the legal norms the legislators have chosen to govern us and that they have communicated to us through symbols. How else could they communicate those norms to us? Through telepathy? But one more thing about legal interpretation to keep in mind. When interpretation reveals that the enacted norm is a rule, the interpretive process continues to flesh out the rule's content. When, however, interpretation reveals that the enacted norm is a standard, the interpretive process is at an end. For fleshing out the standard's content is a matter of first-order practical reasoning, which is not interpretation. Rather, it is politics. To this point, I've been laying groundwork. I've introduced politics, law, rules, standards, and interpretation. And I've distinguished between following rules and first-order practical reasoning. With these things in mind, let us return to the overarching topic, the relation of law and politics. In my opinion, the most important aspect of the relation is one I've written about often. It's what my friend and occasional co-author, Fred Schauer, calls the asymmetry of authority, and what I call the gap. And both he and I believe it is the single most important and revealing prism through which to view legal phenomena. What is the gap, and why does it exist? Put succinctly, the gap is the difference between what rational legislators' first-order reasoning tells them they should require you to do and what your first-order reasoning tells you you should do. The gap arises because, as I've said, determinate rules are necessary to settle what should be done and thus avert the moral costs of uncertainty, disagreement, and lack of coordination. But rules settle by being relatively simple, blunt, and rigid. They cannot capture all the nuance and complexity to which first-order practical reasoning will attend. And if everyone had the same values, and even if the legislators did their job perfectly and enacted the ideal set of rules, those rules would often dictate acts that first-order practical reasoning would veto. In that case, we will face a dilemma. Our practical reasoning will tell us that the legislator's practical reasoning, politics, should lead the legislators to require us to follow rules that our practical reasoning tells us we should not follow. Our standards tell us we need to implement them through rules that our standards also tell us to disobey. There is, I believe, no way to eliminate this gap. The problem is not that we are not angels. The problem is that we are not omniscient gods. Omniscient gods could live by standards alone. Do the right thing would be the only law they need. For even if they were not angels, they would know what is the right thing to do when someone disobeyed. So we who are not omniscient gods need rules. But rules, even ideal rules, will prescribe conduct that our first-order practical reasons reject. To put it in its near paradoxical form, our first-order practical reasons dictate that we should have rules that dictate acts that our first-order practical reasons reject. Therein lies the gap. I will discuss briefly the various strategies offered to close the gap and tell you why I believe they all fail. One strategy, what Fred Schauer calls presumptive positivism, tells us to put a thumb on the scales in favor of what the rules prescribe. The problem is that, first, this only narrows but does not close the gap, and second, and more fundamentally, our first-order practical reason can give no weight to such a presumption. A second strategy found in the writings of Joseph Raz is to treat rules as exclusionary reasons. Once a rule applies to us, we must not act on the reasons on which the rule is based. The problem is that although rules purport to exclude acting for reasons that the rule is based on if such an action differs from what the rule prescribes, this just restates the problem of the gap rather than solves it. Or if it solves it, it does so by fiat. A third strategy, one that looks more promising, is closing the gap by imposing sanctions on rule violators. The thought is that the prospect of sanctions will align the actor's first-order reasons with what the rules require. Unfortunately, this strategy too fails. For one thing, sanctions give actors prudential reasons to abide by rules, but they do not necessarily give actors moral reasons to do so. And if the sanctions are severe enough to turn the prudential reasons into moral reasons, they need judges who are willing to apply them to rule violators who the judges know acted on their first-order practical reasons and for that reason do not deserve punishment. Moreover, the judges themselves are subject to the gap. The rules requiring them to sanction rule violators may conflict with the judges' first-order practical reasons. And who will sanction the judges who follow their first-order reasons rather than the rules? Unless judges are automatons when it comes to sanctioning rule violators, sanctions will not eliminate the gap. Philosopher Jeffrey Brand Ballard has an entire book on the problem of the gap as it applies to judges. And I will, at the end of this talk, tell you of my own experience with judges confronting the gap. A fourth strategy is deception. That is, close the gap in favor of rule following by deceiving the public into believing that the rules align with their first-order practical reasons. Make them into rule fetishists. This strategy is similar to what Bernard Williams called government house utilitarianism, a reference to the idea he ascribed to Britain's colonial rulers that it would be more utilitarian to encourage the natives to abide by their local mores than to urge them to act as utilitarians. This strategy is also reflected in Hare's two-level utilitarianism, in which the archangels were conscious utilitarians and the proles were rule followers, and in other two-level forms of consequentialism. But the problems with deceptive theories for closing the gap are, one, how to control the deceivers, and two, how to keep the deceived hermetically sealed off from the knowledge that the deceivers possess. A fifth strategy is just to protest that it is unfair for individuals to arrogate to themselves the privilege to disobey rules that their community has decided should be enacted, and instead to act on the verdicts of their own first-order practical reasons. But if one's first-order practical reason tells one that abiding by the rules is unfair or immoral, in what sense is departing from the rules unfair? The final strategy, one that might seem promising, is what Schauer calls rule-sensitive particularism. The rule-sensitive particularist acts on his first-order practical reason, but his first-order practical reason takes into account the value of having rules and the consequent disvalue of undermining the rules by flouting them, which occurs if one's flouting the rules leads others to follow suit. This strategy will not eliminate the gap. One might flout the rule undetected, or one's flouting the rules may not affect others' behavior for other reasons. But it should narrow the gap considerably, or so it might appear. The problem is that the rule-sensitive particularist narrows the gap in the direction of compliance with rules only if most others are not rule-sensitive particularists but are rule fetishists. For the value of the rules that goes into the rule-sensitive particularist calculus is highest when others are rule followers. As more people become rule-sensitive particularists and are aware of that fact, the less value will they attach to the rules. And if everyone were a rule-sensitive particularist, the value of the rules would be zero in their first-order practical reason. So here's the upshot. If we equate first-order practical reasoning, the reasoning we engage in under standards or when deciding what rules to enact, with politics, and equate rules with law, then while politics may tell us we should have law, politics seems simultaneously to tell us that we cannot really have it. Law may be for us like the intention to drink the vile liquid in Gregory Kafka's Toxin Puzzle. I'll just briefly tell you what that is for those of you who aren't familiar with the reference. The toxin puzzle is this: the genie comes and tells you that if you intend tomorrow at 10 a.m. to drink this liquid, which is going to make you, it tastes vile, it'll make you nauseous for a while, but it will have no lasting effects. If you intend tonight at midnight to drink it tomorrow morning at 10 a.m., then $1 million will be deposited irrevocably in your bank account. So you think, gee, well, it's worth $1 million to drink this. But you know now that at 10 a.m. tomorrow, the money will either be in your bank account or it won't. And if it's in your bank account, there's no reason to drink the liquid. And if it isn't, there's no reason to drink the liquid. So you know that at 10 a.m. tomorrow, you will have no reason to drink the liquid. And thus, when you know that you will have no reason to drink the liquid, you can't intend at midnight to drink the liquid tomorrow. And thus, you don't get the $1 million. That's the toxin puzzle. And I'm analogizing that to the relation of law and politics. Law tells you, politics tells you that it would be good to have law. The problem is, can you have it, no matter how good it would be to have it? As I said, I think this gap between rules and first-order practical reasoning, between law and politics, is the most powerful prism through which to view legal phenomena. It can explain the fact that some judges prefer rules and some prefer standards. Preferences frequently reflected in the opposition of the majority and the dissenters. It can explain changes in legal doctrine over time. When standards prevail, there is a movement to translate them into rules. But when rules prevail, there is a movement to wipe them away in favor of standards. There is a grass is always greener phenomenon because we want both the virtues of rules and the virtues of standards, and we cannot have them simultaneously. I should add that the gap also explains our opposed reactions to bureaucrats. When they act under vague standards, we feel like Kafka's Joseph K., so totally at sea, and we want to know what the rules are. But when they act under rules and make no exceptions, when first-order reasoning favors exceptions, they become caricatures in our eyes, soulless, rule-following martinettes. We want clear rules, except when we don't. Finally, let me briefly relay the results of my experiment with judges and the gap. I was on a panel at both the West Coast and East Coast conferences of federal bankruptcy judges. There were about 150 judges in my panel's audience at each conference, and no judges in the audience at the first conference were in the audience at the second. Our panel gave the audience 3 vignettes involving clear bankruptcy rules and fact patterns in which application of those rules would seem terribly unfair to a party. We asked the judges to consider whether in those vignettes they would follow the rules or depart from them and do what appears fair. We precluded all other options, including novel reinterpretations of the facts, dissembling, resigning, and so forth. Interestingly, in both conferences, approximately half the judges said they would follow the rules and half said they would not. Half stood on one side of the gap and half on the other. So here is the bottom line. I equate law with rules that settle determinately what must be done. And I equate politics with first-order practical reasoning, the reasoning that produces the rules and the reasoning that standards invite. Politics leads to law, but politics then conflicts with it. The question for me is, if law is desirable, as I believe it is it nonetheless possible? And if so, how? Thank you.
Thank you, Professor Alexander. You began with a question and you ended with a question, and I'm sure if you didn't have to observe our time limits, you would have answered that question. But
no, that's okay.
But you've left a challenge for our 2 panelists. My role as moderator is simply to encourage spirited debate, but I would be curious to know from the panelists what they think about the definitions of politics and law, that about the definitions of politics and law that we have just heard, and how they would compare them to, say, classical definitions such as politics as the art of ordering our lives together, law as an ordinance of reason made by those who care for the community and the common good. And so we begin with Professor Stoner.
Okay, well, thank you very much. Thanks to the Federalist Society, Professor Glendon, Dean Minow, and for the invitation to speak. I prepared a few remarks. I think they'll speak to that, and will keep me on time to read what I wrote. By the accident of the weather, you know, we were originally scheduled for February, we end up talking about this question of law and politics during the very week in which it is front and center in the polity, with Judge Gorsuch's promise, so to speak, to build a wall between law and politics. We owe Professor Alexander thanks, I think, for his thoughtful attempt to bring clarity to the issue by stepping back from the usual terms of debate in the polity and the Senate, by introducing a jurisprudential analysis. Although I think he does deliver on his promise to bring clarity to the question of the relation of law and politics, I'm afraid that by the end of my remarks, I'm going to attribute to him a confusion or two, and so he can straighten me out. But lest this be thought a complaint about that, I want to say that I don't agree with your supposition right away that confusion always leads to political disaster, much less that clarity is a necessary condition for wise policy. If it were, I think there would rarely be compromise. Though I do agree that we're obliged as professors to do our best to be clear. So I want to begin with a point of agreement between us, and then suggest where I think he errs and what can be done to repair the fault. I agree that what he calls rule-sensitive particularism is the most promising way to close this gap he identifies between legislated rules and, to quote him, what first-order reasoning tells you you should do. That is, the gap between law and, I think, not politics, but conscience. As he was counting through the strategies to close the gap, I was looking for this one, and I was pleased when I saw it. I think it corresponds to Aquinas' reason why, although there's no strict obligation to obey an unjust law, obedience ought sometimes to be given to avoid scandal, that is, leading others, perhaps of less refined conscience, to think that laws can be disobeyed whenever they want. I don't think the distinction is so rigid between the rule-sensitive and the rule-fetishists, despite my reference to refinement. As Tocqueville noted that even the best philosopher relies on other minds for 1,000 things, so most of us find it necessary or convenient to rely on thousands of rules without inquiring too precisely into their desirability or their justice, even if from time to time we raise objections to one or the other. I like to think of myself as someone who's sensitive to the rules that govern the classroom and the duties and privileges of students and faculty. But I leave to others to worry about the details of paychecks and pensions and parking, the three most important things, I suppose, for a faculty member, at least this age, and just follow those rules, however grudgingly. And that's just to consider matters of university regulations, not to mention all the other rules that one follows in daily life. Part of the gap between general rules and judgment in circumstances is what Aristotle identifies as properly settled by equity. That is, the ability of a judge to recognize when the letter of the law would do an injustice against the intention of the author of the law. Acting equitably requires good judgment, a little learning to discern the legislator's intention, and good faith to follow it. But it seems to me to be a step that an experienced judge learns to take, not a leap in the dark. Nor do I think, with Ronald Dworkin, that when a judge steps beyond the letter of the law, he necessarily substitutes his own opinions or first-order judgments, unless, of course, he's looking for opportunities to do so. If we can recognize bad faith in the marketplace, why can't we see the same in court? The error in Professor Alexander's argument, I think, is in equating politics with first-order judgments by individuals, or toggling back and forth between a group or a part, and between a particular actor and all or many actors. Political life involves essentially thinking and acting in common. And if this sometimes issues in partisanship or even in groupthink, It's also the very source of political authority and political power, at least if Hannah Arendt is to be believed. Because we are not only rational beings, but political animals, we tend to reason in groups, and thus imperfectly, accepting opinions as axioms and persuasive arguments as proofs. If this means that political actors think less clearly than angels or archangels or omniscient gods, much less omniscient gods, I concede the point. But also note that in better polities and political movements, the thought of individuals bonded together is probably stronger than the thought of most every one of them on his own, as we learn reasons from one another, direct our imaginings to what others can similarly imagine, and develop a shared vocabulary for articulating our hopes and fears. I don't mean that this is merely an organic process of fellow feeling, though friendship and fellowship in politics should not be ignored. I do think that the gap between the group and the individual is not endemic, but rather rare, and that what appears to be such a gap is more likely to be the friction at the interface of different groups or parties, where individuals find themselves separated, so to speak, from their usual pack. Law emerges from shared thought and common opinion, not independent of them. This is obvious in the case of customary law or common law, as we still call it. But it's also true, I think, of legislation, which generally passes only as a result of widespread agreement, not merely a momentary coincidence of wills. No small part of the confusion in our society between law and politics today results from our misunderstanding the legislative power, I think, which, when described as lawmaking power, gives rise to the idea that law can be made from scratch or hewn from a mass, like a pie or a sculpture, typically best when done by a single artist. Instead, I think the legislative power should be defined as it is in Blackstone, as the power to declare or to change the law. This definition supposes that law always exists in any society, that, so to speak, authoritative public opinion abhors a vacuum. But the objective of legislative action is to encapsulate and settle that understanding in writing, or when wrongs or mischiefs are discovered, to remedy them by new enactments. Thinking about law in this way, which I think reflects its reality, ought to discipline our expectations of political change, and perhaps also our process of lawmaking, urging us to understand the state of the law before any new enactment, and to carefully consider what needs reform and why. It ought to make us skeptical of grand schemes to refashion whole areas of law and policy, seeing that they need to be woven into the fabric of the law if they are to persist and accomplish their purpose. Sometimes striking reforms succeed and grow widely accepted. Think of workers' compensation statutes in the early 20th century, for example, which replaced tangled webs of liability. Or maybe bankruptcy law itself, which was meant to allow individuals to disentangle themselves from their debts without succumbing to them. But reforms fail, I think, both when they create tangled webs of their own, and when they pay scant attention to the need for law to be embodied in common, or at least widely shared opinion in order to win consent. And it would not be the least of the advantages of such a view of legislation that it might remind judges that changing the law is not their function. Applying established law to existing cases, jumping the inevitable gap between the general rules and the myriad circumstances that differ person by person and case by case, in a way that does justice and that attends to equity, is itself a noble task. Why don't judges think so anymore? Why don't they think that's enough? So to venture to answer Professor Alexander's concluding question about the relation of law and politics, law is possible only when it emerges from politics, and politics is most respectable when it acts to preserve and improve the law. Thank you.
So you have one answer to the question. Now, Dr. Franck.
Thank you. First, I want to say thank you to Dean Minow and Professor Glendon and the Harvard Federalist Society. This is my first visit to Harvard Law School. I'm very glad to be here with my good friend Jim Stoner and my friend Larry Alexander, who's a provocateur, as always. Today, in giving us a capsule version of a problem that Larry Alexander has thought about for a long time. He has not failed to provoke. I, on the other hand, am coming to this problem for the first time, and my tentative reply to his very interesting remarks is that the gap of which he speaks is more starkly a problem in theory than it may prove to be in practice. It's a very useful explanatory prism for tackling problems, but is it really as much of a problem itself as he makes it out to be? Maybe not. The gap is this, again, with respect to first-order moral reasoning. It's the difference between what the law requires and what you think you should do. Quoting Alexander now, rules will prescribe conduct that our first-order practical reasons reject, end quote. If they agree, the law is unnecessary, as we would do as it bids without its bidding. If they disagree, no good reason can be adduced to do as the law bids, and so law fails. Professor Alexander considers and rejects various possibilities for closing the gap. I'm not quite convinced by each and every one of his rejections. For example, when he speaks of, in his words, rule violators who the judges know acted on their first-order practical reasons and for that reason do not deserve punishment, end of quote, I know of no reason to accept, without more, the conclusion that a rule violator acting on a conviction that a rule is wrong does not deserve punishment. Be that as it may, what seems insoluble in theory is something we muddle through, for the most part, successfully in practice. Professor Alexander himself admits that some strategies narrow the gap, and taken together they may do so considerably. As much as his paradox may trouble us, nonetheless, we may observe that most people are law-abiding most of the time, that the instances in which they are scofflaws, for instance, jaywalking across Massachusetts Avenue, are of little consequence, and that the great clashes between the law and the truly conscientious moral reasoner are not high-frequency phenomena. Moreover, his stark statement of the gap strips away some potentially important nuances. For instance, one instance of the gap might raise the question, is the law's command to us that we violate what we hold to be exceptionless moral prohibitions? This, thankfully, I think, will be rare, but it does happen. Or, on the other hand, is the law's command that we fulfill a legal duty that is, for us, a matter of moral indifference? This is far more usual. And in all the space between those two poles, in the space between the command to fulfill a legal duty that is for us a matter of moral indifference and the command to do a wrong our morality prohibits, there's a wide zone of greater and lesser conflicts. I will echo some of what Professor Stoner has said when I say that when the gap opens up, there are also resolutions of the conflict it engenders that can themselves generate new legal rules or preserve the one at stake in the instant case. There is, for instance, the rule of lenity. There is equity jurisprudence. There are executive pardons. There are exemption-carving statutes intending to deal with the gap in particular cases like Religious Freedom Restoration Acts. There's jury nullification, which is controversial but recognized as just from time to time. And of course, there are constitutional challenges to laws themselves in the name of some law that trumps the law challenged. Professor Alexander's passing remark about a judge treating a rule violator's moral reasons as a reason to conclude he deserves no punishment, and his closing vignette about the bankruptcy judges dividing more or less evenly on whether to follow the rule or do the fair thing, they suggest something about where the gap is truly problematic, in my view, namely in the real-world behavior patterns of the judiciary, not among the citizenry generally. To put the matter baldly, Alexander fashion, on a proportional basis, one may probably say that practical rule flouting occurs with greater frequency among judges than among the population as a whole. This in particular is a gap very much worth pondering, particularly as we come to the end of a week in Washington spent on an inconclusive and frustrating conversation between senators and a Supreme Court nominee on the subject of the relation between law and politics. One of the things that makes the spectacle of this past week so disheartening, senators who want to know what results a judge will choose in future cases, and a nominee who won't even comment on past ones, is that we are operating in an environment in which virtually everyone agrees that the Constitution simply is what the judges or justices say it is. So the stakes are very high. I should note that Professor Alexander and his occasional collaborator, Fred Schauer, have vigorously defended the consensus view of judicial supremacy, arguing that it performs an essential settlement function, in their words. Now, I don't think that conclusion follows from or even coexists easily with the Alexander-Schauer thesis on the gap, or the asymmetry of authority. It appears rather to be an effort on their part to close the gap by main force in one field. But in fact, it exacerbates the problem. For when judges find that the rule of the Constitution chafes them, they push it aside in favor of first-order practical reasoning of their own, and then call that the law of the Constitution. They are encouraged to do this by the institutional armor that has grown up around the doctrine of judicial supremacy and finality. So perhaps Professor Alexander can offer us some thoughts on how the settlement function of judicial supremacy can in practice lead to such unsettling results with respect to the gap he has so eloquently described. Thank you.
Thank you, Dr. Franck. The program now calls for as much interchange among the panelists as they would like. And Professor Alexander, would you like to react to the comments?
Well, I appreciate the comments, and just we do muddle through, right? And by just in response to the last comment by Matthew Franck. It is. I've had some second thoughts about judicial review and judicial finality. What you have there, to the extent that judges use their first order reasoning to depart from, in this case, constitutional rules that purport to bind them, and establish a new rule protected by the carapace of judicial supremacy. Then you have it's one more illustration of the problem of the gap, and it's problematic from that standpoint. I mean, if we want justices to be bound by the rules, both constitutional and legislative, because that's what the Constitution says is supreme. Not on the other hand, judges confront what they see as the gap, even if they see it wrongly, and so it's unsurprising, first, that you have judicial departures. That's not surprising. That's to be predicted. And secondly, it's not surprising that they would try to insulate their departures from being retrenched by proclaiming in Cooper versus Aaron a kind of large measure of supremacy. I do agree that to the extent we share sort of the kind of common culture that produced the common law and the like, the problems are much less serious. There are ways we have of negotiating and feeling that the rules that bind us are not. They're not. We don't have occasion to re-examine them and to see whether they comport with our first order reasoning. We identify with them. They're our rules as much as they are rules imposed from above somewhere. To the extent we don't have that situation, then we confront. We have a much more serious problem. And I also agree that for the most part, most of the rules that we don't question them because they're really not that important to us. We're perfectly happy to let HR determine how much money comes out of our paycheck for withholding, and other things. We don't. You know, they're just too many rules that we just shouldn't. You know, we don't have time to care about, and much less interest in caring about. That's all true. The bankruptcy cases were interesting because these are starker cases, and for that reason, I thought they were illustrative. How much of life is like that? You know, it's true. Most of the rule flouting that we see on an everyday basis are, you know, sort of low stakes rule flouting, jaywalking. Fred, in his latest book, has a sort of amusing discussion of the differences in cultures in terms of rule abidance. So he says, you know, he observed in Finland, you know, huge numbers of people waiting for the walk sign to go on, even though there were no cars coming, there was nothing, you know. Compare that to other cultures where you wouldn't observe that. So it's true that you know, there are some more sort of rule fetishistic cultures than others, and to the extent you have rule fetishists, that can be good. It can be vital for the society. It can also be, as you know, history has given us other examples of rule fetishist societies that were not so benign. And so, but I appreciate the comments and the criticisms.
Great. Are there any further comments from the panel? If not, the floor is open for questions.
Bored into silence.
Thank you for that wonderful lecture and the great comments. I am taken also by the anecdote about the bankruptcy judges. And I know IBM Watson, the great artificial intelligence exercise, has now mastered the bankruptcy code. This is the machine that now is reading x-rays. And I have very ambivalent feelings about this. Both concerns about the profession and is it going to put us out of business, but also more fundamentally about the morality of law. Just one more comment before I put to you, all of you, the question: would it be a good thing if we could program IBM Watson not just to do the lawyer's work but the judge's work? The one more comment is this: that even with IBM Watson, it's a single code and it's a federal code, and our legal system is much more complicated like that. You can start with the HR department and then move up. We have a federalism. We have overlapping jurisdictions of all sorts. And aren't there good reasons for that have to do with multiple authorities and decentralization and other kinds of conceptions that our founders had? And so even if it were possible, would it be good? And is it possible? That's my question.
Yeah.
Well, who wants to tackle that?
Well, I think that, you know, Watson, I assume, if programmed for the to apply the bankruptcy code, will be the ultimate rule fetishist. I assume that would be so. The half of the 300 judges that we sampled and thing, half of them would be delighted. You know, their job would be a lot easier, and they'd be out of a job essentially. The other half would be quite distressed because they would Watson would not give the relief to the parties that they felt should be given. So it's one of the when we were discussing when first dealing with the gap and discussing sanctions, one way of dealing with this is replacing judges with Watsons who will be perfectly happy to carry out the most severe draconian sanctions to get everybody to fall in line with the rules. whatever their first order reasoning would tell them. Whatever severity of sanction would be required, well, Watson would carry that out. The question is whether judges, human judges, would carry that out.
Thank you. Dr.
Yeah, I think traffic law is already being enforced by the robots, right? I mean, they're sending people bills for pictures that were taken of going through intersections or whatever it is, and I think that's a serious challenge to the law. First of all, it's reversed the presumption of innocence, and because Americans spend so much time in the car, wherever you start with, whatever starts in traffic is going to seed its way through life. And so I think that reversal of the presumption of innocence is a real problem now. And I think but then it does press you to say, what is the problem? Is it just that some people don't have the courage of their convictions, or they get soft, or something like that? I think it has to do with a human being being able to understand other human beings and to think of rule following, not mechanically, but as what it is to incorporate a rule into your reason. So there, I guess, I don't know if there's the difference between the rule and the reason, but that, as you said in one of your responses, people would make the rule their own. Well, I think any time one obeys a rule, you have to make it your own in a way. Even if you're making it your own, you're inevitably interpreting when you're making it your own, much less when someone is standing outside of you and the rule and trying to decide where you are.
Other questions? If not, many thanks to the Federalist Society for making this such a memorable Vaughan program, and thank you, Dean Minow, for attending, and thank you, Professor Alexander, for raising a question that we will all be talking about over lunch, and thank you, Dr. Franck and Professor Stoner, for your comments.